Good morning. My name is Brigit Toebes. I am Professor of Health Law in a Global Context at the Faculty of Law, and I also work at the Department of Transboundary Legal Studies. And it's a real pleasure and honor for me to chair this morning session on the TRICI-Law workshop, Change in International Law, Rules of Change or Changing Rules, in the beautiful old courtroom that is from the year 1755. I'm now going to give the floor to my dear colleagues Panos Mercouris and Sotirios Janos Lekas for some opening remarks.
Thank you very much, Professor Toebes. Good morning, everybody. I'm delighted to have you here, both those who have joined us in physical presence, but also our colleagues, speakers, and participants who have joined us online. We are delighted to have this entire day devoted to one of the workshops of the TRICI-Law project, which I know it's the way it is written, most people say it as TRICI-Law, and it makes sense, but we wanted in this project to indicate that it is, no, this is not correction. It's an explanation of what the project is about. So we call it TRICI-Law because we wanted to suggest that this is a tricky project. It was our way to make a little bit of fun with the law, that the interpretation of customary international law is a topic that is somewhat under-researched, a very tricky area, and we hope that through the workshops, through the discussion that we will have also today, that this will become more and more clear. First of all, I'd like also to thank our speakers, again, both those who are present, who've taken the time to venture through the maze that is nowadays Schiphol Airport, and then the trains to come to Groningen. They've managed to do this successfully without, not without some obstacles here and there, but they all persevered. And also to our colleagues who join us online as well. We thank you for taking the time, and we're very much looking forward to your presentation. I will not be presenting each one of you. I'll leave that task to the chairs. As Professor Toebes mentioned, we're here today in the old courtroom, which surprisingly is situated in the Faculty of Theology and Religious Studies, and not the Faculty of Law. I don't know if there is a hidden meaning behind that. Maybe that is a topic for another workshop. It is perhaps an ideal, in my view, setting to discuss the theme of the workshop today, which is change in international law, rules of change or changing rules, which of course courts and tribunals are always a part of. According to legend, and Professor Toebes may correct me, there is also, the people I think online may not be able to see it, there is a set of stairs in this room that goes down, and it was a holding cell or a prison, I think.
Well, it is my understanding that the prisoners were then led to a council. That's what I read, but we should study this more, Panos.
Absolutely, absolutely. So a new grant is being made as we speak. So if anybody is ideas we found extremely objectionable, you know the way that we'll go. So joking aside, thank you all very much. We very much look forward to all the presentations, and I'll yield the floor now to the main driving force behind this workshop, Dr. Lekas, who will explain a little bit more about the ideas and topics that we'll discuss. Thank you.
Thanks very much, Panos, and thanks very much, Brigit, for introducing me. Now, I don't know whether I am the main driving force, but you know. What I intend to do now is to set a little bit the scene and the tone of what we will be trying to do today. In terms of, I will try to, start with a few questions that I think are common amongst all the papers, and introduce the panels, but not the speakers, because I hope that the chairs can do that. So in terms of the theme, well, one of the trickiest, pun intended, issues we came up whilst conducting this project was the issue of change. Because in the final analysis, one of the main driving forces behind change in international law is or could be interpretation. But we wanted to interrogate this a little bit more. So the main topic, the main theme is how does legal change come about in international law? And from a legal perspective, what are the tools through which or with which rules of international law change? Now, as the larger theme, the larger in the background looms the sort of contradiction between a formal approach, and this is the rules of change part of the subtitle. Rules of change lay down how change comes about, and this is something that in the final analysis it means that change is regulated by legal rules, much like everything else. According to positivist accounts, every legal system has some of these. Otherwise it's not a legal system. So from this perspective, a whole line of questions arises. What are these rules? What are the pitfalls? Are they good enough? Are they bad enough? Are they effective? Are they responsive? Should they change? But also there is an existential issue there. Is this formalism even there? Or is this formalism even useful? Or in the final analysis, rules of international law are changing all the time. So there is an inherent plasticity in all the rules of international law, be that treaties, because they are laid down in vague terms, be that customary international law, because it is unwritten and it is unwritten for a reason, or general principles of law, because they are general and, in the final analysis, they are completely inconclusive, so to speak. But still, there is a line of analysis there. How to counter opportunism and provisionism? How can one distinguish good things like the responsiveness of the international legal system towards, global pandemics or climate change, and, the revisionism of, an oligarch in Eastern Europe trying to, conquer a huge part of his neighbor. So this is the largest thing, what I think are the existential questions behind that, and I think that our panels largely reflect this, and also they cover these issues in detail. So we tried to make two panels which are sort of which are debating to each other. The first panel, I think the core of the first panel is the idea of rules of change. So our first rules of change in the law of treaties, rules of change in jus cogens, and rules of change in customary international law. And I think that, and I'm not trying to raise expectations or put some of my expectations to project my expectations to you, but I think the papers by Christina Binder, Tladi, and Katie Johnston actually reflect this idea of rules of change, formal change. The second panel, I think one of the underlying themes is the plasticity of international law, and also, again, I don't want to project my own expectations, but I think Brigit is going to focus more on interpretation and how, through interpretation, sometimes treaties are sort of escaping the control of the parties. Thomas Kleinlein will be interrogating the idea of change in relation to use cogents and actually how the idea of hierarchy is intrinsically inimical towards change and how we can balance these things. And of course, Enzo Canizzaro is going to talk about interpretation and conflict as mechanisms of change. So I hope that this reflects these general themes that we are trying to interrogate through the project, with a view to understand a little bit better how rules of interpretation can come about, how change also comes about. Now, I thank you very much for introducing me. I think it's time to introduce the chairs of the panels. Brigit Toebes, who is going to chair the first panel, is a professor of health law in a global context at the University of Groningen and director of the Aleta Jacob School of Public Health. She has written extensively on issues of international health law and international human rights law, and I think her research agenda focuses on the interstices between these two fields of law. She has published in legal journals, but also in public health and interdisciplinary journals. She is the chair of the Dutch Society of Health Law and the co-chair of the Global Health Law Group in the International Law Association. She's also a member of the Dutch Council and Committee on Ethics and Law, amongst many of the positions that she has previously held and the many accolades that she has received before. Our second panel, our afternoon panel, will be chaired by Professor Wessel, who is the Vice Dean of the Law Faculty and a Professor of European Law at the University of Groningen. He's also the Vice President of the European Society of International Law. He has published a lot on several issues of EU law, and he is very recognizable in issues on the actions of the EU in a global context. And his scholarship is also very pertinent to our project and our discussion today, as he has co-authored a seminal article on treaty stagnation back in 2014 in the European Journal of International Law. Now, without further ado, I would like to proceed with our first panel.
We have three speakers in this panel called Rules of Change in the Theory of Sources of International Law. And they are Christina Binder, Tladi, and Katie Johnston. And Dire, I hope I pronounce it properly, is available online. And the other speakers, Christina Binder, and Katie Johnston, are sitting now next to me. And they have made a huge effort to come here. From München and Nottingham. It was not an easy trip, it was a tricky trip that you made, and we really appreciated that you're here and that you were able to sustain the stress that you had to undergo for your travels. At least I find these things very stressful, and again, thank you so much for making the effort to be here in Groningen with us. We really appreciate it. And that brings me to the first speaker, Christina Binder from the Universität der Bundeswehr, München. Christina, I think we met 4 years ago in Sydney. And actually, it was the biennial conference of the International Law Association, but we met in the hotel pool. So that's how we started to talk. And it's a real pleasure to see you here again. And to give the floor to you, for you to talk about your topic entitled Change and the Law of Treaties, or Means and Limits to Accommodate Change. Christina, you have the floor.
Can you hear me? No. Many thanks for the kind introduction. Actually, we met this year again, walking up a mountain, again at the biannual conference in Lisbon.
Is your microphone working properly? Yes? Is this one better? Then maybe you can sit here. Is that better for the sound? And then you have to speak a bit like this in the microphone.
Like that? Yeah, no.
Yeah.
You have to find the optimal distance to the mic, so it's going to be, I hope to improve throughout, or to start right away. No, it's a real pleasure to be here in this lovely courtroom, notwithstanding slight obstacles during travels. No, it's really great to be here. Many thanks for the invitation. Actually, what I intend to do in my talk is to look at change and the rules of change from the existing treaty framework. So really to investigate and explore the tension between stability and change, and to see on the one hand, and actually I made a small handout to give the main structure of my talk, to explore on the one hand, which means do we have to accommodate change within a treaty, and obviously their interpretation will be a major means, but also others as margin of appreciation, or also the good faith in compliance with the treaty. So starting from the Pacta sunt servanda rule and the duty to comply with treaties in good faith, and to see to what extent can we accommodate change within a treaty. And then on the other hand, and that might lead perhaps a little bit further than your project, when in instances where the accommodation of change is not possible within the treaty, to look into the rules of non-performance, to say, okay, which means to treaty parties, and there again I take the perspective of the treaty parties and the framework of the treaty, to engage in non-performance, to non-comply with their treaty obligations on the one hand, under the law of treaties, obviously rebus sixtantibus, Article 62, changed circumstances, supervening impossibility of performance, but then also the state responsibility, necessity, force majeure, and then the specific, which options are offered by specific treaty regimes, and to what extent do they differ from general international law. So I roughly divide my presentation in these two parts. Accommodation of change within a treaty, which means we have there, and that might be more. I'm going to put certain focus on that because that's a little bit more in the overall frame of your project. And then in a second part, a little bit more briefer, I'm going to focus on change outside the treaty framework. Why does it matter so much to speak about change in the law of treaties? Well, treaties freeze time at the moment of adoption, which differs from customary international law, which, and I would want to cite Dupuy, follows reality in degrees of mimicry. And that's different in the law of treaties, especially in the huge multilateral treaty frameworks, which are difficult to be face difficulties to be amended. There, the accommodation of change the question of how to accommodate change really is a major topic. And this in particular also with the changing structure of international law, where we see that actually with changing state obligations, the more and more direct and tighter regulations and obligations at domestic level. So change matters even more the stricter the treaty obligations are at domestic level. So also, and that will matter in the end when I talk about specific treaty regimes. So to start with change, accommodation of change within a treaty, actually basically three options are there. Of course, rules of interpretation, evolutionary dynamic interpretation of treaties, but then the systemic integration of treaties, Article 31(3)(c) is a major means to accommodate change in the sense that actually a treaty is to be interpreted in light of the rules existing at the time, which are applicable between the parties. However, there are, and actually what we see in particular, treaty bodies, institutions which are permanently set up within treaty regimes as human rights bodies or also the WTO dispute settlement body engage in such evolutionary and dynamic interpretation. Well, a living instrument doctrine of the European Court of Human Rights is very much, is all too well known. So there are dynamic interpretation, evolutionary interpretation, and the principle of systemic integration as major means to accommodate change. However, still there are clear limits. In the end, it boils down to, on the one hand, obviously, somehow it needs to be founded in state consent, that there needs to be the parties need to, when agreeing on the treaty, need to have somehow considered that it should be interpreted, and when agreeing on the treaty text is state consent reflected in generic terms, reflected in broad formulations in the treaty. That's on the one hand, and then obviously the treaty text in the sense of, and there still ICJ, the interpretation of these treaties where it refers to the duty of the court to interpret treaties and not to revise them. Or also the arbitral tribunal in the Laguna del Desierto case, where it says that interpretation is a judicial function whose purpose is to determine the precise meaning of a provision, but which cannot change it. So there are limits set by the treaty as regards dynamic interpretation of treaty obligations. That's as far as the evolutionary dynamic interpretation is concerned. Another means to accommodate change within a treaty is the restrictive obligation interpretation of treaty obligations by the party struck by the change. Even though it's not mentioned in the means of interpretation, it can be deduced from the object and purpose of a treaty intended to have established a certain synalagma in compliance with treaty obligations of the treaty parties. So it can be read into the treaty via Article 31, paragraph 1. And when a state is, or a treaty party is struck by a change, is burdened by a change, then in order to bring the synalagma into the right proportion, actually its burden of compliance would be eased. Similar to that, although rather situated in the context of application of treaties and not so much interpretation, is the margin of appreciation. In compliance with treaty obligations, actually the margin of appreciation which is left to a treaty party in compliance with the treaty, once again, same as the European Court of Human Rights leaves states a margin in compliance with treaty obligations. It focuses on two pillars, text of the treaty provision, but then also a certain notion of self-restraint. So judicial deference is implied, and one of the preconditions when as regards the margin of appreciation. So on the one hand, to return to the first option, the text provision of the treaty, the normative flexibility of treaty provisions is key. So a certain open-endedness, like good faith, proportionality, reasonableness, or necessity. So we need a certain, either with Yuval-Shani standard type, discretionary or result-oriented treaty provision. So once again, we have certain limits to the margin of appreciation. This is on the one hand the text of the treaty, but then on the other hand the position and actually the attitude of the respective tribunal, granting a certain deference. And then finally, the principle of good faith, which is also a rule of change in the sense that it can require a state a reasonable exercise. It requires a reasonable exercise of treaty rights, and it then prevents abusive reliance. By requiring that attitude, it would require also not to ask for anything unreasonable from the treaty partner, and that imply that when a treaty party is struck by a change, it would need a certain retention in the not restrictive attitude as regards what is required in terms of compliance performance obligations. The mandatory adaptation of the treaty by a treaty organ on the principle of in reliance on good faith finds, however, limits in the accommodation of change by when actually the burden is shifted of the obligations on the other treaty parties. So in that sense, there are limits when actually the synalagma in treaty compliance is over, and one the other treaty partners are burdened by increased performance obligations. So the kind of procedural solution was in the Gabčíkovo-Nočmoroš case, negotiations as expression of good faith, where actually the International Court of Justice asked the parties, Slovakia and Hungary, to find an agreed solution within the cooperative context of the treaty. However, we see such an open-ended demand or to require to understand the 1977 treaty in the light of its object and purpose, find its limits when the parties cannot find a solution. So and cannot agree on anything. So today, even after 25 years later, parties have not found any solution, and the case is still pending. So to rely on good faith, requiring for negotiations, also finds their limits in that in that context. So we are faced with limits when it comes to accommodation change within an existing treaty regime. This most clearly is shown in the rejection of the principle of approximate application of a treaty by the International Court of Justice, once again in the Gabčíkovo-Nočmoroš case, where actually Slovakia tried to rely on on the principle of approximate application, asking for an application of the treaty which cannot be applied literally as closely as possible to its purpose. Obviously, there are obvious dangers in this undertaking because we lack exact criteria as to how the treaty should be approximately applied, what is to be understood by approximity. And so I think rightly, as Judge Bejari argued in the separate opinion, approximate application endangers the legal certainty and stability of treaty obligations. So in that sense, in particular, I would say the rejection of the approximate application of the treaty shows the limits to accommodate change within the treaty. Which brings me now to the second part of the presentation, the instruments and means when it comes to failures to accommodate change. Obviously, and I would focus on three parts. Non-performance under the general law of treaty, termination and suspension under Article 61-62, then non-performance under the law of state responsibility, and then performance in specific treaty regimes. Non-performance, and the main argument being that actually on the non-performance options under general international law really put rightly the emphasis on treaty stability and offer only very limited means to accommodate change, in the sense that they are really focused on, they provide only very restrictive criteria as regards non-performance. So as is very well known, Article 62, framed very restrictively, allows only in very exceptional circumstances the treaty termination framed as double negative, and this shows also in the very limited state practice and judicial practice. Basically, it was only the European Court of Justice in the Ruggie case which accepted reliance on Article 62 also under very specific circumstances. Article 61, impossibility of performance, also very high substantive threshold, so very limited means to accommodate change in the general law of treaties. State responsibility, necessity and force majeure to a certain extent broaden states' option not to perform treaty obligations under the law of state responsibility, although they are also framed very restrictively. They function differently, being part of the secondary so international law, by the means that we need first a breach of obligations to enter into the law of state responsibility, but that means also still in ongoing proceedings procedurally, a state can rely on necessity to argue that the wrongfulness of its compliance is precluded. So procedurally they are easier to implement than law of treaties, which are subject to quite complex procedures when a state relies on the termination grounds of the law of treaties. And then also in terms of consequences, law of state responsibility differs, because basically the performance starts again when the circumstance precluding the wrongfulness ends. And so in that sense, the law of state responsibility broadens a state's option as regards accommodation of change to the engaged in non-performance when being struck by a change. So for these reasons, actually there is a certain diversification of possibilities to react to subsequent changes. In general, in international law, by the state responsibility complementing the law of treaties. However, given the very strict criteria and conditions of application, these options are very limited. And so what we see in particular, specific treaty regimes as human rights law, investment law, international economic law, or the law of the sea, kind of provide for treaty-specific rules who, on the one hand, as regards termination, mainly actually all regimes allow for termination, mainly linked to procedural criteria, not to substantive conditions. However, there is very little state practice, even though so permanent exit usually is not an option. What is increasingly required is temporary non-performance, temporary derogation from treaty obligations in case of change. And so especially treaty-specific derogation provisions as necessity provisions in human rights treaties, etc., as we also saw now with the COVID-19 pandemic, are increasingly provide on the one hand for system-specific accommodation of change, for instance, in the human rights field, that they are subject to very clear criteria. On the other hand, there is an international monitoring involved to follow and examine whether states comply with the conditions. So treaty-specific derogation clauses differ from general international law in allowing for non-performance in a treaty-specific way, and to a certain extent, even though old-fashioned, that's can be called a sign of the fragmentation of international law, that we have increasingly differentiated instruments in the different treaty regimes to accommodate change outside the regime. So to conclude, I would, when it comes to accommodation of change within treaties, actually there are three different, or inside, so to say, three different means. Obviously, evolutionary dynamic interpretation, systemic integration, then a margin of appreciation granted to a state in the performance of the treaty, and third, the principle of good faith as more dynamic, substantive element, which focuses less on the treaty text, but more on the substance of the treaty. And then the accommodation of change outside the treaty, non-performance under general international law, law of treaty, state responsibility, and non-performance under the law in specific treaty regimes which allow for treaty-specific non-performance, and especially temporary derogation in specific treaty regimes, not permanent exit, but there is also according need and relevant practice accordingly. So rules of change, changing rules. I would say it's also there in terms of rules of change when dealing with general international law and specific treaty regimes. What we see really, general international law on the one hand is flexible enough, especially the golden rules of interpretation of international law, to accommodate a variety of different means to deal with change. And this shows that overall the framework provided by general international law to deal with change, in particular with the rules of interpretation, it still is a valid framework. So rules of change in the broadest sense, changing means to deal with change, they still may be to a certain extent accommodated within broad framing and the different elements of Article 31, particular 1 and 3 of the Vienna Convention, but in particular Article 31, paragraph 1, with the different elements which are shifted in different means, but always in accordance and with focus on the respective treaty framework. Okay, that's many thanks, and yeah, I'm looking forward to questions.
Thank you very much, Christina, for your very rich presentation on the rules of change, both inside and outside of the treaty. Is there anybody who would like to ask a question of clarification? We have quite a bit of time in this session, so for now we have some time for question of clarification, and we will have more time to discuss after the three presentations. So anybody would like to ask maybe a more specific question? I see Marcel Brus in the room who feels very restless. Welcome, Marcel Brus, our colleague from Transboundary Legal Studies and International Law Section Chair.
Thank you. Yes, it was a very interesting talk, and well, some of the questions came up which would be relevant for this, and maybe also a kind of clarification. We are used to look at, you spoke about treaties, that there is one kind of treaty, and so many different treaties. And if I want to make a very good distinction, let's say you can look at treaties as contracts between parties, and you can see them as legislation or regulation. And it's important also, I think, for the ownership of what is the role of the states in the change. When they object to a legislative treaty, it would be less important than a contractual treaty, I would say. The last part of your presentation, a concrete question came up. There's no discussion about the ending by the EU of the Energy Charter Treaty, because it makes it very difficult to achieve the goals of energy transition, because energy companies can rely on the investment clauses in that treaty, even 20 years after the ending of the treaty. How would you see that? How in your presentation, if the EU would step out of the EEC and say, we only recognize this for 10 years, would that be an internal or an external argument? Or what argument could we use? Is that then the change of necessity, which can be argued to say, okay, when you see that the contract is clear, 20 years, sunset clause. But if you see it as regulation, you say, yes, our world has changed. Everybody sees that we have to. And if we have to pay all these conditions to the firms, then we can do it. Thank you.
Yeah, many thanks for the question indeed. Well, it depends very much on the treaty, in the sense what kind of obligation. And that I hinted on when I said this changing structure of international law. So with treatment where you have from horizontal obligations towards vertical obligations, and then also the law-making treaties are different, or the geology of international law. And of course, it depends the type of obligation also stands in direct relation on the rules of change, so to say. So which practice matters, or also to what extent, well, on the one hand, the need to accommodate change is increased the tighter the obligations at internal level are felt, and then on the other hand, which practice matters as regards change. But that I leave on the side because it's a whole. In terms of your second question, then, and that's somehow linked to, well, the treaties, investment treaties. When you what's the legal status of investors? Are they rights holders? Are they the nature of investor rights? And to a certain extent, it depends on how to either grandfather clause, or to say, okay, a treaty provides for a certain protection of investments for an extended time after. Can states abolish that and abolish that protection which is provided in the treaty for new considerations? And I would, that's to the extent that it's explicitly under the law of treaties, and it's explicitly agreed upon, and they explicitly abolish the protection of investors, that can be done. So it's still in the hands of states to also do away with established clauses, or like the sunset clauses, which allow for even after the termination, but it needs to be done explicitly. And then the reason, the question of to what extent can well, the Energy Charter Treaty, it shows how difficult it is actually to amend treaties to that extent, and the Rebus Sixtantibus doctrine, or the rules of general international law, would, as framed so restrictively, so they would not, they can be an incentive, but they would not be a valid clause, reason under the law of treaties to, well, first terminate and then to engage in a new one. It's just too restrictive in terms of criteria of application.
Thanks very much, and I think there will be ample time to discuss further throughout the day. Let's continue with the next speaker. Dieren, is it Dieren? Do I pronounce that well? Dieren. So I'm extremely pleased to welcome welcome Dieren Tladi from the University of Pretoria and the International Law Commission. Dieren, where are you currently? Are you in Geneva or in Pretoria?
In Pretoria. Can you hear me? Yeah.
And let's see, can we hear you properly? Can you maybe?
I can move closer. Is that a little better?
Yes, this is good. So,
Okay.
Dina, you have the floor with your presentation called "Change and Peremptory Norms of General International Law." Welcome.
Thank you. Thank you very much. And just to say, I would also have liked very much to be there in that beautiful hall. In fact, as Soterios and Panos will tell you, it's not for lack of trying that I didn't make it, but well, things just simply didn't work out. But I'm very happy to be here nonetheless, to be able to share some thoughts. It's always very difficult to follow Christina with her very clear and concise and structured presentation, but I will do my best. Let me maybe just to begin start off by saying that I adopt a rather a broad view of change, and so for me in this context, change includes not only modification. I think normally when one thinks about change, one thinks about modification of rules. But I also include abrogation of rules. I also include the emergence of new rules as part of what I would say sort of change. And if I were to place international law on a scale or what do you call it, a continuum, and on the one hand you have sort of stability, resistance to change, and on the other hand of the continuum you have flexibility, openness to change, responsiveness, those kinds of things. I think that in general, international law, and I think that Christina's presentation sort of attests to this, even with all the limitations, would be placed closer to this side of the continuum, closer to the side of flexibility and openness to change. I leave aside one aspect that might be confused with this flexibility, and that is because international law doesn't have a judicial or legislative authority, the law can very often be seen to be in the eye of the beholder. So I leave that side, that issue aside, because that's not so much about change, but more about how international law is interpreted and understood. But if you take, and I'm sure that the next presentation will go into a little bit of detail on this, I mean, the very idea of customary international law as law that is made to the practice of change, the practice of states, we all expect practice of states will change in response to whatever circumstances, geopolitical context, social context, technological context. So all of these things will result in state conduct changing, and assuming that all the requirements are met, then the rules of customary international law so also changing. In the presentation by Christina, she took us through a number of ways in which treaty law, even though this, I think, the more stable, if you like, of the two main sources of law, is certainly more flexible than, and I like what Marcel, the question and the linkage, or the question of treaties as legislation and contracts, certainly more flexible than its written counterparts or written cousins in domestic law, legislation and contracts. And Christina took us sort of through the various ways in which treaty law and treaties accommodate change. So one thing that I didn't hear, for example, is purpose of interpretation. I mean, the very idea of purpose of interpretation for me is also a way in which treaty law facilitates an evolutive approach to interpretation. I mean, Christina spoke about Article 31, and here I guess I would place even a greater emphasis on subsequent agreements and subsequent practice as techniques, as means which facilitate, which accommodate change, and of course also systemic integration. One other aspect, when one looks at international law in general, that I think is reflective of international law's openness to change is, I think, the very horizontality of international law, the very idea that states can decide to contract out of rules. States can decide that here's this general rule. We don't want this general rule to apply to us. We want a particular rule to apply to us as a group of states. That also, I think, is a form of change, and that's clearly indicative of where international law stands in the spectrum and in the scale. Now, peremptory norms of general international law use Coggins challenge this flexibility, ease, openness to change, or at least as far as it relates to norms of use Coggins. If you think about use Coggins in its most classical, traditional conception, use Coggins is a product of, or use Coggins is connected to natural law. And of course, one of the more common, in fact, I would not say just more common, but more dominant strands of natural law is that its norms are immutable. Of course, there are other conceptions of natural law, but the most dominant one is this notion that natural law is immutable. And so certainly if one thinks about use Coggins in its classical traditional sense, then one will come to the conclusion that use Coggins norms under this classical traditional sense were immutable. They existed independent of time and place, and so they were unchangeable, thus moving to this end of the spectrum. Of course, we know that this is not the conception of use Coggins that was put forward by the International Law Commission in the 1960s, and more importantly than that, that was accepted by states at the Vienna Conference in 1969. That conception of use Coggins, which is the conception that is the most dominant, the conception that is ruling, if you like, I like to say refuses to be categorized in either the natural law or the positive law box, despite valiant attempts by proponents on either side. That conception of use Coggins builds or integrates actually the very notion of change, the modification, into its very definition, which we find in Article 53, right? So norms of use Coggins are those that are accepted and recognized by the international community of states as a whole as norms that may not be derogated from, and which may only be modified by norms having by subsequent norm of the same character, right? So the very definition acknowledges the possibility of change, acknowledges the possibility of evolution. Article 64 of the Vienna Convention acknowledges, is based upon the idea of the possibility of emergence of Coggins norms. So very much different from the classical traditional conception of use Coggins. But even if we accept this new notion, this new conception of international law, and we accept the possibility, this new notion, a new conception of use Coggins, and we accept the possibility of change, of modification, of emergence of new use Coggins norms, in theory, the threshold for change, of course, some may even question this, but the threshold for change, the threshold for modification, the threshold for emergence is still very high. So that even under this new conception, use Coggins norms or norms of use Coggins are generally resistant to change, right? So they remain resistant to change. Still, the question is an important question. What are the mechanics for change? How do we change? How do we modify norms of use Coggins? Medhat Payande wrote a chapter in a book recently where he says it is understandable that the ILC in the 1960s did not address modification with respect to use Coggins. It is understandable that when the ILC dealt with use cogens in its subsequent work on state responsibility, fragmentation, and so on, it is understandable that the Commission would not have addressed the modification, but he says that he would have thought that in its most recent work, the International Law Commission would have addressed modification. Of course, it doesn't, right? So it doesn't address change, it doesn't address modification, at least not directly, or perhaps the best way to put it is not comprehensively, because it does address it. It addresses it in the commentary, sort of in an almost flippant way, if I may say so myself. But the question of modification, change of use cogens, and the difficulty of this change, I think is particularly contentious because of the ILC's approach on or to the basis of use cogens. So the ILC in its most recent work says that the most common basis for use cogens is custom international law. And then later on it says a rule of custom international law does not arise if it conflicts with use cogens. This might seem to suggest, and certainly there were some members of the Commission that made this observation, and even some states in their comments, this might seem to suggest that notwithstanding what Article 53 says, that in fact modification is not possible under the ILC's structure in its 2022 draft conclusions. In a sense, the point that is being made is that there's some incoherence. On the one hand, in 2022, based on its previous work and based on the Vienna Convention, the ILC, of course, says use cogens norms can be modified, can change. But then on the other hand, when you look at its statements on custom international law, this suggests that it is in fact not possible. To this point, I would just simply say, in fact, I just simply say the following. The point of departure must be that use cogens norms are difficult to modify, that they are resistant to change. Now, it's not impossible to change it, but it's difficult, right? Hence, and this is what I guess what we mean by a high threshold for modification, in the same way that there's a high threshold for emergence. As a result, the mechanics of modifying, of changing norms of use cogens must be so difficult that it is almost seems impossible to change it. And I want to give an example of so this is our Constitution. And our Constitution has a section. In this section, it states what our basic values are. To change that particular, so that would be the equivalent of our use cogens in this country. Change that section of the Constitution would require 75% majority of Parliament, and it would require 6 out of the 9 provinces in South Africa. Not even Mandela's first government, with its high support, could achieve that threshold. I say this because whenever I try to explain how, even under what the ILC has described with respect to use cogens and its interaction with custom international law, whenever I try to explain how even under that conception, modification can still take place, the response I often get is, but that sounds far-fetched, sounds impossible. And of course, I would say, well, it is far-fetched. It should sound far-fetched. It should sound impossible because it is meant to be difficult. So how can it happen? A practice that is accepted as law, so rule of custom international, a practice that is accepted as law, and at the same time accepted and recognized as one from which no derogation is permitted, can in fact modify an existing norm of use cogens. In other words, a practice, even if it is accepted, or at least to put it differently, a practice, even if it is accepted as law, will not modify a norm of jus cogens, in fact, does not even create a rule of custom international law, if it is not accepted and recognized as one from which no derogation is permitted, or at least if it is not accepted and recognized as having the character of jus cogens. Now, again, so one might well say, well, it's impossible for states to both accept some practice inconsistent with jus cogens as law if they don't also accept and recognize it as meeting the threshold for peremptoriness. And of course, that's probably correct. And all that it shows, I think, and all that it means is that in cases where states accept a practice inconsistent with jus cogens as law, they will almost always, if not always, accept that practice as meeting the threshold of jus cogens. If not, then the only thing I can say is that that norm of jus cogens was probably not a norm of jus cogens to begin with. The best way to try to apply this is by looking at the rules on the use of force, and in particular self-defense, which I have done in a few publications in the past. But I know that I know that Professor Kleinlein's paper later this afternoon will do that, so I won't repeat much of what I've said in the past. The only thing I will say is that if you take, for example, humanitarian intervention as an example, because the original understanding of the prohibition on the use of force did not include humanitarian intervention, the only way that that particular exception can modify the existing rule is if it is accepted and recognized by the international community as a whole as also having a peremptory status. And by the way, in my view, much of the arguments about the modification of the rules on the use of force fail not because of the jus cogens argument, but actually fail either because they simply don't meet the requirements for treaty law, Article 51 modification through interpretation, whatever, nor do they meet to the requirements for custom international law. But that's a different story. Having said all of that about the difficulty of modifying norms of jus cogens, and so how jus cogens brings international law a little bit closer to the stability side, I think it is also important to say that there are instances, there are circumstances in which jus cogens normativity can arise as a response to particular circumstances. And so in other words, that jus cogens itself accommodates change, or jus cogens itself is the fruit of change. I think this is borne out by looking at the list of norms that the ILC normally puts forward as constituting norms of jus cogens. So the prohibition on the use of force, genocide, crimes against humanity, no doubt emerge as norms of jus cogens in response to the atrocities of World War II. Self-determination, or the right to self-determination, no doubt arises in response to the decolonization movement. The prohibition of discrimination no doubt arises from the collective rejection of apartheid South Africa's policies on racial discrimination, and so on and so on and so on and so on. This raises, and I'll stop here, the question whether, and why not, in fact, rather than so whether, given the enormous crisis that the world is facing relating to certain environmental issues, in particular climate change, why those particular rules haven't been or haven't emerged as norms of jus cogens. And I'll stop there. Thank you very much for your attention.
Thank you very much, Dire, for your interesting presentation, pitching a number of really interesting thoughts. As an international health lawyer, the question comes to my mind, could protection of health ever become a jus cogens norm? I'm looking at the audience and to see if there are any questions of clarification or elaboration. André de Hoog, our colleague, has the floor.
Thank you, Professor Tladi, for your presentation. There's one point which hasn't come up specifically. which is, of course, that the modification of has to come up against the question of conflict, because the modifying norm would have to conflict in some way with the rule of jus cogens to begin with. Now, most modifications will conflict. If you create new exceptions to a prohibition, or if you want to limit the scope of the rule of jus cogens or eliminate it altogether, that would seem to suggest conflict. The only thing that might not actually conflict is an expansion of the jus cogens character. Take, for instance, the prohibition of the use of force, applicable only in international relations, that it would be expanded to cover the use of force in internal. Of course, I don't see that happening in any way. That's unlikely development because it will put bonus on armed opposition groups to use force against governments. So I don't see that kind of thing happening. But that would, I think, be the only scenario where modification really is possible, an expansion of the jus cogens character without any kind of conflict.
I will ask, the roving mic is not clear. Even when the question to Christina was posed, I could hear the voice, but I can't actually hear the question, the words. So I'll just ask maybe if somebody could repeat the question.
Andre, would you mind come over here and summarize your question very briefly to Dieren?
Yeah.
Over here.
Is this better? Okay. Very quickly, because I have summarized. Whether or not modification is a problem depends on conflict. No, that's still not.
Without the mic.
Can try.
Yeah, Andre, this one works. Please come over.
Okay. Does this work? Yes. So very quickly, because I have to summarize, modification is only a problem if there is a conflict with an norm. That means that new exceptions or elimination of the jus cogens character of a norm or a limitation of the jus cogens character of a norm would be problematic. The only modification which is not problematic would be when you expand the jus cogens character of an existing peremptory norm.
Excellent, thank you.
Yes, I mean, I think that's correct. I would just say that I think that even if there is a conflict, so in situations where you're not talking about the expansion of the norm, I think even then there isn't a problem. I mean, it's certainly a lot more difficult, but it's not impossible even in that instance. I think the reason why it's often portrayed as being impossible, at least when one looks at the structure that we give, is because there's an assumption that the various elements that are required must all happen sequentially, that they can't all happen at the same place, that you can't have the practice, acceptance as law, and acceptance and recognition for the purpose of jus cogens all happening at the same time. So absolutely, I mean, I think you're right that when you're speaking about expansion of a norm, when there's no conflict, then this question about the relationship between customary international law and jus cogens and the difficulty that arises therefrom does not arise, absolutely.
Thank you so much, Dieren, and please stay with us because we will have more discussion at the end of this session. And I see, Christina, do you have? Would you like to briefly reflect? Yes.
Yeah, I just wanted to thank you for mentioning subsequent agreements and subsequent practice. I have not touched upon, but obviously, in particular, the subsequent practice part, which is nicely situated at the between the treaty law and customary law. perhaps in the discussion we can reflect, because obviously also how, for instance, the interpretation of a treaty monitoring institution then induces state practice and generates then certain kind of even a possible change in the understanding and it going further than the original text of the treaty. Yeah, thanks a lot. That was a nice addition.
Thank you, Christina. That brings us to the third speaker of this morning, and I'm very pleased to introduce again Katie Johnston from the University of Liverpool with her presentation, Changing Custom, Identification of State Practice and Opinio Juris in the Context of Existing Customary International Law. Let's first check if your microphone is good.
Hello? Hello? Can you hear me? Thank you. Good morning. It's a pleasure to be here, and thank you to Thanos and Soterios for organizing this great event. My presentation actually is going to pick up on some themes that Professor Tladi and Henri have already raised. In this short paper, I will argue that there is no separate process or set of secondary rules for the modification of customary international law. It is the same test, the two-element test for the identification of customary international law, widespread and representative state practice accompanied by opinio juris, that must be applied when determining whether a change to custom has occurred. However, even if there is no separate process for the modification of custom, the question of how custom can change nevertheless raises distinct issues. Even if it is the same test for identification of custom that is being applied, the kind of change to custom alleged to have occurred, for example, whether a previously identified customary norm is being expanded, as we've discussed, or a new customary exception is being created, will impact the application of this test, affecting how state practice and opinio juris are identified. And to illustrate this, I'll consider two concrete examples: the expansion of an existing customary prohibition and the restriction of an existing customary prohibition. So first of all, to understand how customary international law can change, we need to understand the nature of customary international law. Treaty norms are created, and as Christina has shown us, modified through formal process. Generally, without considering the content of the treaty norm being created, one can determine whether the criteria for the conclusion of a treaty, set out in the VCLT and custom, have been fulfilled by the instrument in whose text that purported treaty norm is expressed. If those criteria are met, the very fulfillment of those criteria that give the treaty validity. By contrast, international law is not just unwritten, but I would argue informal. The two elements of state practice and opinio juris are themselves constitutive of...
Excuse me, Katie, you wanted to say something? Okay, can you please, would you kindly move over here?
Can you hear me now? Okay, so just to summarize, I'm going to argue that there's no separate set of rules or processes for the modification of customary international law, but rather it is the same test for the identification of custom that needs to be applied to determine if a change has occurred. Nevertheless, the kind of change that may have occurred to customary international law will affect how this test for identification has applied. It will affect how this... Can I maybe sit there? Because your mic is working better. Third time lucky. But the kind of change that you're assessing, whether or not it has occurred, will affect how this test for identification custom is applied. And so change to custom does raise its own distinct issues, even if it is the same test. So treaty norms, I was just saying, are created through formal processes without looking at the content of the alleged treaty norm contained in the text of the instrument. Using the criteria in the Vienna Convention and customary international law, we can determine whether these formal criteria for the validity of the treaty have been met. And if these criteria are fulfilled, it is the very fulfillment of these criteria that make the treaty norm valid. By contrast, customary international law is not just unwritten but informal. The two elements of state practice and opinio juris are themselves constitutive of customary international law. Customary international law norms may be identified, but it is not this process of identification, whether by a tribunal, a state, or a scholar, that creates customary international law. Whether or not someone conducts an evaluation of state practice and opinio juris and concludes that they are sufficient for a given customary norm to be identified has no impact, other than as a piece of opinio juris in itself, if that person conducting the identification is a state, on the existence of customary international law. By extension, the identification of a customary norm which can be said to be supported by state practice and opinio juris at a particular time does not freeze custom. As Dira said, state conduct continues to change over time, and customary international law is the sum of all the practice and opinio juris of states at a particular moment, which will continue developing without interruption, regardless of whether anybody identifies a particular norm on that basis. The customary international law norm is really just the characterization that is given to the content of that state practice at a particular moment in time. Mendelssohn has described this ongoing nature of the process through the metaphor of building a house. He said, the process of customary law is a continuing one, which does not stop when the rule has emerged any more than the life of a house stops after the builders have left the site, the keys have been handed over to the new owner. The house will continue to be altered and repaired, and these repairs will strengthen it, or at least prolong its life, just as neglect or damage to the fabric will hasten its collapse or destruction. And when customary international law is understood in this way, there can be no separate process or set of secondary rules for the modification of custom. Whether one is seeking to evaluate if a particular customary norm exists or continues to exist, or to determine its content at a given time, it's the same test for identification of custom that must be applied. That is there a sufficiently widespread and representative state practice accompanied by opinio juris? On this basis, to speak of a change to a customary international norm simply means that the customary international norm identified, following an evaluation of state practice and opinio juris by a particular actor at a particular time, differs from the customary international norm identified as regulating that same subject matter at an earlier point in time. And that's how I will understand change in customary international law. Nevertheless, even if there is no separate process or set of rules for the modification of custom, the question of how custom can change, as I said, raises distinct issues. In particular, although it is the same test for identification that is being applied, the kind of state practice and evidence of opinio juris required to satisfy that test will differ depending on the kind of change alleged to have occurred. Or to build on Mendelssohn's house metaphor, what we look for to determine whether an alteration to a house has been completed will depend on whether one is building a new house from scratch, adding a new extension, or demolishing the house to replace it with an apartment block. First, the nature of the new customary international law norm being identified may be prohibitive, permissive, prescriptive, and so on, which will impact the kind of supportive state practice that will need to be shown to identify the customary international law norm. For a permissive norm, a supportive state practice would consist of states performing the conduct said to be permitted by the customary norm. For a prohibitive norm, a supportive state practice would be states refraining from performing the conduct said to be prohibited by the customary norm, and so on. Second, where one is assessing whether an alleged change to custom has occurred, the test for identification of custom is necessarily being applied in a context where custom regulating the particular subject matter has previously been identified. And this is significant because the context of existing international law norms, which form the background against which this test for identification of custom is applied, will impact how we evaluate the existence of state practice and opinio juris. In particular, the context of existing international law affects how we can identify supportive state practice and the inferences we can make about the opinio juris of states participating in that practice. So where state practice is consistent with the previously identified customary international law, it's sometimes difficult to identify that as state practice without evidence of opinio juris showing that this is legally relevant conduct. By contrast, where state practice is inconsistent with the custom that has previously been identified before, I would argue that we can draw certain inferences about the opinio juris of states engaging in that practice. The impact these factors have on how the test for identification of custom is applied in situations of change can be seen more concretely if we consider two examples, the expansion and the restriction of a previously identified customary international law norm. In this case, I'll consider customary prohibition that's already been identified. So applying the analysis of customary international law just outlined, the expansion of a customary international law prohibition is really the identification of a customary norm, which includes within its prohibitive scope new kinds of conduct, in addition to the conduct prohibited by a customary norm identified as regulating that same subject matter at an earlier point in time. So we can imagine a scenario where custom prohibits direct uses of force by one state's military against another state, but does not prohibit indirect uses of force, that is, the sending of armed bands to conduct attacks on another state's territory. For a custom to change so that acts of indirect force are now considered to be prohibited by customary international law, what would be needed would be sufficient state practice and opinio juris to identify a new customary prohibition on indirect uses of force. And the state practice that would support the existence of such a customary norm would therefore be a widespread and representative practice of states abstaining from acts of indirect force, accompanied by opinio juris. So in cases of expansion of a customary international law prohibition, the underlying context, the background of international law in which the test for identification of custom is being applied, will always be one where custom does not otherwise prohibit that conduct that constitutes a supportive state practice. And as a result, it would be difficult to establish that this inaction by states actually constitutes legally relevant conduct for the purpose of identifying custom. States, by omitting to perform acts of indirect force, are acting, or rather not acting, in a manner that is perfectly consistent with the previously identified customary norm. In a situation where custom contains only a prohibition on direct force, it is clearly lawful also to abstain from acts of indirect force. States may omit to act for many reasons or no reasons, and there's no possibility to infer from this omission that this reflects a conscious choice, much less an opinio juris for a new customary prohibition. What is needed if this inaction is to be considered as a state practice in support of a new customary prohibition on indirect force is evidence that this abstention is based on their being conscious of a duty to abstain. Thus, the difficulty in establishing new customary prohibitions, as the International Law Commission has pointed out, the necessity for the evidence of opinio juris, not just, I would argue, as one half of the test for identification of custom, but also to establish that there is even a supportive state practice at all, to make a practice of omission, to make inaction into a supportive practice in favour of a new customary prohibition. A more difficult question raised by the expansion of a customary prohibition, I think, concerns when identification of new custom should be categorised as a change to pre-existing custom. Assuming in the scenario I set out that there is sufficient state practice and evidence of opinio juris for a customary prohibition on indirect force to be identified, should this be properly categorised as a change to customary international law? That is, do we end up in a situation where we now have a customary prohibition on direct force that already existed, coexisting with a separate, more recently identified customary prohibition on indirect uses of force? Or is it more accurate to say that in this case, the customary prohibition on force has been changed, its scope has been expanded? I think this is a difficult question, and ultimately how a change of this kind is best analysed, I think, must turn on the opinio juris of states when they are recognising this new practice as being prohibited by custom. To take a concrete example, the General Assembly resolution on a definition of aggression, adopted without a vote, may be considered, with all due caution, of course, as evidence of the opinio juris of those states that adopted it. The text of this resolution makes clear, I think, that acts of aggression, including indirect attacks, are uses of force for the purpose of both the Charter and the customary prohibitions on force. And this seems, based on the text, to have been treated by states adopting the resolution as the expansion of the existing customary prohibition on the use of force, not as the creation of a separate customary prohibition on indirect force. Now, in most cases, whether this kind of change to custom is characterized as the identification of a new customary norm or a change to a previously identified norm will not make a difference. What matters is that custom now prohibits both direct and indirect uses of force. As I argued at the outset, it's state practice and opinio juris that constitutes custom, and to speak of norms is really just how we characterize the content of that customary law. So whether it's a change to an existing norm or a new one doesn't really make a difference. However, the potential issues raised by these different characterizations become clear if one considers that the prohibition on direct force was likely, even at the time of the adoption of the definition of aggression in 1974, to have enjoyed jus cogens status. For the change in custom to be characterized as an expansion of that customary jus cogens norm, it would need to be shown not just that the test for identification of custom has met, but, as Dira was saying, also the more demanding test for the identification of a new jus cogens norm. And I think that's possible. I think it can happen. I don't want to trespass too much on Dira's territory, but maybe we could discuss it in the discussion afterwards of how you could show that that jus cogens prohibition has expanded. But essentially, I agree that it turns on the opinio juris of states, and if a sufficient number of them recognize this previous customary prohibition, this previous jus cogens prohibition as having expanded to create the broader jus cogens prohibition. Turning to the restriction of a customary international law norm, a restriction of a customary prohibition, applying the analysis set out at the start, would be the identification of a customary norm which, by comparison with a customary norm identified as regulating that subject matter at an earlier point, excludes certain conduct from its scope. And the obvious example would be a change characterized as the creation of an exception to a previously identified customary international law norm. Arguments that an exception to a customary prohibition has emerged are common in practice, if rarely successful. For example, in both the jurisdictional immunities of the state case and the arrest warrant case, one party argued unsuccessfully for the existence of a permissive customary exception to an established customary norm that prohibited the exercise of jurisdiction. Arguments as to the existence of new exceptions also persist in the jus ad bellum, as we've discussed. The United Kingdom continues to invoke a novel right of humanitarian intervention, most recently as a purported justification for unlawful use of force against Syria in 2018. But such a right would presumably constitute a new exception to the customary prohibition on force, as well as derogating from the jus cogens norm in the jus ad bellum. At first glance, however, it is not immediately obvious why demonstrating the existence of new customary exceptions should be so difficult. Where a party is arguing for the existence of a new customary exception to a prohibition, in effect, what is required is to demonstrate sufficient state practice and opinio juris to identify a new permissive customary norm that partly replaces the previously identified customary prohibition. As a permissive customary norm, the supportive state practice that would need to be shown would be a practice of states performing the conduct that is now alleged permitted by the customary exception. That is, for example, states exercising jurisdiction even where a party claims that they would qualify for immunity under the previously established prohibition. Those incidents of supportive state practice will, in this case, the case of restriction of a prohibition, be inconsistent with the previously identified customary international law. This, of course, means that the states performing the first incidents of state practice supporting a new exception are at risk of their conduct being viewed as an internationally wrongful act. But from the perspective of changing the law rather than state responsibility, the significance of this inconsistency with the underlying customary law is rather the inferences one can draw about the opinio juris of states performing or reacting to that practice as a result. Unlike the situation of expansion of a prohibition discussed earlier, it seems that in this scenario there is neither the difficulty of identifying state practice that consists of omissions, nor of finding evidence of opinio juris where practice could support either the existing custom or the alleged new customary norm. To the contrary, in circumstances where a state is consistently acting contrary to existing law, it seems reasonable, in my view, to interpret this as implying an acceptance by that state, or at least a claim, that their conduct is permitted by custom, that is, an opinio juris. Otherwise, the state is simply repeatedly acting in violation of international law. Similarly, turning to the reactions of other states, presumably a state acting contrary to international law raises at least some expectation of a negative response by other states. This expectation will be strengthened, for example, if that silent state is itself the victim of an apparent internationally wrongful act. A failure by another state to react negatively, conduct inconsistent with previously identified custom, may therefore imply that state's acceptance that the conduct is now permitted by custom. Taken together, this is a bit troubling because it would appear to suggest that the identification of new customary exceptions is in fact more easily accomplished than the expansion of customary norms discussed earlier. Due to this possibility to infer opinio juris on the part of both the acting and non-reacting states in the face of the supportive practice. Yet, as we know, in practice, states struggle to demonstrate the existence of new exceptions to customary international norms. And intuitively, it seems like it must be more difficult to establish an exception to an established rule than to establish one in a vacuum where there is no existing law. And I think there are these two countervailing reasons why demonstrating a change in custom by identifying a new exception will be challenging. First, given that the alleged customary exception is being identified in the context of previously identified customary prohibition, this is what makes it a situation of change, that there's existing customary law. There will be an existing body of state practice in support of that prohibitive customary norm. So one reason why it is difficult to successfully demonstrate the existence of a customary exception is that to meet that same widespread and representative standard, the quantity of state practice in support of the new permissive exception will need to be sufficient to outweigh the existing incidence of state practice supporting the prohibition on the conduct in question. So in reality, a greater amount of state practice will be required to identify a customary exception, change in custom, than, for example, to identify a new permissive customary norm in a vacuum, where there is no pre-existing customary international law on that topic. Again, the test for identification of custom remains the same, but its application in practice is impacted by the type of change to custom that is being evaluated and the structure of the norms that are being identified. Second, while in principle, as I said, I think it's possible to infer opinio juris or a permissive customary norm from a supportive practice where that conduct is prohibited by the previously identified customary law. In practice, the circumstances in which such an inference of opinio juris will be possible are limited. That limits the scope of this rather radical sounding argument about inferring opinio juris from a supportive practice. In many cases, the broader context will negate any inference of opinio juris on the part of the acting state. For example, where states have previously expressed their opposition to existence of an alleged customary norm, this must prevent any inference of opinio juris from their silence at a later point in time. Instead, evidence of their new, more recent opinio juris as to the lawfulness of that conduct will be required for a change in the law. And this seems particularly likely to be the case where the change being considered is the creation of an exception, where the newly permissible, supposedly, conduct needs to be carved out of the very same conduct that had previously been accepted by states as prohibited by customary international law. It may even be that states have explicitly rejected the specific exception being claimed to exist. So when in 2018 the UK, France and the USA conducted airstrikes against Syria, some states reacted by explicitly condemning the strikes as illegal, although many more remained silent. Yet even though this conduct was a flagrant breach of the customary international prohibition on force, it does not seem correct to infer from this lack of negative reaction that those states accepted such uses of force as now being permitted by a new customary exception as claimed by the UK. The broader context in which a substantial group of states had already clearly rejected this view, notably, for example, the states of the G77, was an important factor in assessing the meaning to be drawn from their later lack of reaction. In addition, the jus cogens status of the prohibition on force also militates against any inference of opinio juris from a failure to react to its violation. Now, it's possible to make the opposite argument that a violation of a jus cogens norm should generate an even stronger expectation of a negative reaction to that practice from other states. But of course, if you follow that to its conclusion, you end up with the perverse result that jus cogens norms become easier to change because the expectation for reaction and the inferences to be drawn from non-reaction are much stronger. But I think that's not possible. To conclude then, by considering these two scenarios, expansion and restriction of a customary prohibition, I hope to have shown that even if assessing change to custom is simply a case of applying the test for identification of custom in the context of existing customary international law, there's really nothing simple about it. The question of how change to custom can occur raises distinct questions about how the test for identification is applied in this context of existing customary international law on the same subject matter, and in particular that affects the evaluation of state practice and opinio juris. The type of change alleged to have occurred, the identification of a permissive or a prohibitive norm, the expansion or restriction of a previously identified norm, will impact the evaluation of those two elements of state practice and opinio juris. And hopefully a more fine-grained approach by breaking down customary norms in this way will allow for a more rigorous evaluation of claims, such as that by the United Kingdom, that changes to customary international law have occurred. Thank you.
Thank you, Katie, for your nuanced presentation. Nothing is simple in this field. I'm first looking at the audience, and in particular, Oviso, my colleagues Oviso, Lottie, and also this afternoon's speakers, if they have any question of clarification, elaboration, and then also we are going to start our discussion. Is there any further questions specifically in response to Katie's presentation? And I'm now going to stand up because we're all going to use this microphone. Panos, would you mind coming over to speak into this microphone? We're all going to be active during this last hour, and you can speak in this microphone, and then everybody can hear you. Yeah. Also, Dieren.
Feeling like I'm the accused person here. So thank you very much, Katie, for the wonderful presentation. There's a lot, really a lot to unpack. One question just to start the conversation is, you mentioned the analogy with a house and everything. Although I do think that doesn't apply only to customary international law, it would also apply to treaties because they're constantly changing unless the parties have expressly declared otherwise. My question would be about possibly the House of Customary International Law kind of intervening in the House of the Treaty. So whether the custom itself, whether when it has been identified or whether it has changed and so on, whether that can eventually conflict and perhaps even supersede or change treaty regimes as long as it has come afterwards. So do you think that there is a solution there, and what would be the approach for that? Thank you.
Thank you. So I guess the question is, can change to custom address the issues that Christina was raising in her presentation? My view is no, because I think when anytime I've read about this issue being addressed, the first thing that people seem to point out is the lack of hierarchy between the sources, seeming to suggest that this means that they can change each other if none of them is inferior or superior to the other. I think what this overlooks is actually the independence of the sources from each other, in that each has its own legislative process, which I think is what we're discussing really today, the different secondary rules. So my view is that a changing customary law could bring about a change in a treaty norm, but it would only be if that practice also simultaneously fulfilled the requirements for modification of the treaty norms, would also fulfill the requirements of 31(3)(b as subsequent practice. So perhaps it is a semantic argument. So perhaps some people would say that is custom changing the treaty. In my view, that's not correct. It's customary and international is changing, and by coincidence, it is also happening to fulfill the requirements for modification of the treaty law by its own terms. I don't think a customary norm could, but for a jus cogens customary norm, of course, which is the exception to this rule. But I think it's the exception that proves the rule. A customary norm that is not jus cogens cannot change the treaty norm unless it happens to fulfill the requirements of treaty law for its modification.
Okay. Thank you, Katie. I'm now giving the microphone to Christina. You wanted to respond to this? And we are also opening the floor for the broader discussion.
Yeah, obviously, as you mentioned, the bridge is Article 31(3). be this subsequent practice, I would still make a distinction between when we have an authoritative monitoring body interpreting the treaty, and then the question of how are the reactions, thinking of the European Court of Human Rights, but also then in distinction to the, for instance, Human Rights Committee. And there I would make the distinction, do states, for instance, have to object to such an interpretation which goes further than the treaty text? Would be a difference whether it is a monitoring body interpreting with binding force as European Court, or as the Human Rights Committee, not with binding force, because there, in order that the treaty rule is not modified, would so a requirement for objection would be only with respect to the European Court of Human Rights interpreting with binding force, as opposed to the Human Rights Committee, where by the non-binding means of interpretation, the duty to react would not be there. So I would kind of slightly, nuance the answer to that.
Thank you. And now I would like to give the floor to Thomas Kleinman, because would you mind coming forward to give you... No, I think this can work if we are all moving around a bit actively and accept the fact that this is the best microphone so that everybody can hear us. Okay, sure.
Hello, can you hear me? Yeah?
Dieren cannot... Well, if you would you mind using this one so that Dieren can hear us? Thank you very much.
So thank you very much to all of you for very insightful presentations. If the chair is okay with that, I have a number of questions that I ask all now and then stay quiet for the rest of the time. So maybe first turning to Christina, you said that the basis for restrictive interpretation, if I understood you correctly, would be the synalagma. And that brings me again to the topic already raised about legislative treaties and contracts. So would this mean that restrictive interpretation only applies to those treaties that have a synalagma, and that is at the same time not legislative treaties? And that somehow makes sense if you think of human rights treaties. However, you could also say that consent is the very reason, state consent, why we somehow need to restrict interpretation. Then the argument wouldn't work. So I asked you about the significance of the synalagma for restrictive interpretation. And then I have a question that maybe goes to both of you about maybe freezing moments in the development of customary international law. And you had that building of the house that comes from Mendelssohn. And I wonder whether there are certain moments in time that are, of course, more important than other moments in time. And that one moment could be that when for the first time the customary rule is somehow spelled out or written down, because you need to make choices. Then how general do you frame the rule? And then, of course, you could say that then that is the moment where interpretation of the customary rule starts. And this, again, would be another significant maybe mode of change, that you first need some written form of the customary rule. And then you start, of course, also interpretation. Yeah? Maybe. So that's the question. And then about the interaction of laws, that goes again to both of you. Would you say that there's a distinction to be made between subsequent practice and customary process, or is it somehow the same, or is it double counting? We count some state practice as both subsequent practice, and it could also be customary interaction. How does this relate to each other? You said that there basically no interaction of sources, but you said there would be a coincidence, so that maybe these interactions are coincidences because, or for the very reason that we need to double count some sort of state practice as both if there is a certain field occupied by a treaty. But maybe this may also be only theoretical questions that have no real telling about practice. And then I have a question for Dira, referring to maybe there's another mechanism that provides for stability of customary international law, and that's about interpretation. I think there is that rule in your draft conclusion that if there's an apparent conflict of a norm, of a normal norm with these Kogans, then you should do everything to avoid that conflict or apparent conflict. And I wonder what the basis of that is, and whether you would say that this is something like a presumption against conflict with these Kogans. Whether this is a correct rephrasement of that rule as a presumption, and what it's based on. Yeah. Thank you very much to all of you.
Thank you, Thomas. And I propose that we also ask, am I correct to understand that you are Canizaro? Please, if you don't mind, come forward and ask your questions, and then we do a round of feedback from speakers. Yes. And please raise your hand, others in the room who also want to. Yeah.
I want to make a question for Christina and a remark for dear Tladi. Christina, you talked brilliantly about the principle of systemic integration, something that is fascinating. All the lawyers naturally tend to thought.
You can't hear you. Maybe it's now too close.
Oh, that might be it.
The miracle of the microphone.
Dia, can you raise your hand if you can hear us?
I can hear you.
Understand the question?
No. Okay.
I'm intimidated.
No, I can hear. So maybe if you can try again. I could hear Thomas clearly, but I can't hear the current question.
Well, let's start from the beginning. Principle of systemic integration. And the main driver in treaty law is probably Article 31.3. But 31.3 presents us the dilemma. And this dilemma, the main dilemma in my view, is the interpretation of the notion of the parties. Who are the parties? And from this interpretation, many implications will flow. If we identify the parties as the parties to dispute, then the interpretation of the treaty will be fragmented according to the reciprocal interpretation which some of the parties can give to the treaty. If we identify the parties as the parties to the treaty to be interpreted, probably we don't find any parties, any possibility to apply Article 31.3, except perhaps customary law, and this is another topic. So I wonder how do you solve this dilemma, which to my view is still unsolved. And for this Tladi, a remark more than a question. I agree that changing existing customary law is difficult, both formally and substantially. Formally, because Article 53 of the Vienna Convention makes it very, very difficult to change existing use covenants. There must be a customary rule, practicing opinio juris or whatever it is, and there must be an acceptance, a recognition of the nature of the rule of a use covenants rule. That means a rule which cannot be derogated. That means that if a rule of use covenants is faithfully complied with, it will never be changed because there is no recognition of another rule accepted and recognized as a use covenants rule which cannot be derogated. But I think that also somebody else mentioned conflict possibly as a factor for change of use covenants. But there are many kinds of conflict. I think that use covenants, like almost every constitution in the world, constitution of a community, have a certain degree of resistance, must have a certain degree of resistance to change. In a way, use covenants is the Ewigkeitsklausel, correctly, which cannot be changed for the eternity. And an exception can be made if we accept the treaty or treaty jargon. It can be changed by interpretation. Interpretation means also occasional collision among use covenants rules. And this is a possibility which to me seems to be very real. Okay, then in the afternoon, possibly I will clarify a bit more my thought. This is just a preliminary remark. Thank you.
Thank you very much. Can I first ask Dire to give a sort of response to the things that have been said, and then we move to the speakers in the room. Thank you, Dire.
Okay, thank you very much. So there were two questions for me. I mean, the first question concerning draft conclusion 20. The reason I didn't mention it, well, there are two reasons I didn't mention it. One is I didn't think about it. But now that you mentioned it, I think it is an interesting point. The reasons put forward by the commentary, or the justification put forward for the commentary, is Article 31.3c. It's almost kind of an extension of Article 31.3c. And if you look at it, if you look at the commentary for that particular draft conclusion, it's one of those draft conclusions that is very thin in terms of support from authoritative material. In fact, apart from literature, I think the only cited case in support of that is the European Court in the Western Sahara case. I mean, in any event, that's the only judicial decision. Everything else is literature. For me, that rule is really a rule of logic. It's a rule of logic. If the idea is you want to maintain rules, and so in that sense, you're right, it does actually promote stability, because without that rule, there will be greater modification, greater change through the abrogation of rules and the invalidation of rules. So in that sense, for me, it's purely a rule of logic, but a rule of logic that is, according to the Commission, based on an interpretation of Article 31.3c, and therefore systemic integration. As far as the second question is concerned, I actually don't see a dilemma. I mean, I know that there is this debate, but for me, it's clear that in Article 31, and maybe it's because I haven't thought about it as carefully and as much as you thought about it, but the parties refers to the parties to the treaty, because otherwise, as you say, what we're encouraging is different interpretations and different meanings of the treaties from party to party. And as Christina said, I think at the very beginning, the object of interpretation is to find, I think you said the one true meaning or the true meaning, and so on. So that would certainly go against that as a purpose if the idea of seeing Article 31.3c and the reference to the parties there as the parties to the dispute. So for me, it's clear that it's the parties to the treaty that you have to find. Now, you're absolutely right that means you're excluding a lot of rules. But again, so what, right? So if there aren't any rules that are applicable, that's fine. Then you've got other means of interpretation. You don't have to say you're going to include many. The objective ought not to be the quantity of the rules included in the interpretation. The objective ought to be to try to find the true meaning and content of the treaty. I think those are the two questions that were posed to.
Thank you very much, Dire. And I'm now looking at the other speakers in the room. Who would like to go first? Yes, Tina?
Please, sir. Good idea. Perhaps I can just continue where Dire ended. For me, it would also clearly be the parties to the treaty, because the very object and whole undertaking of treaty interpretation is to elucidate the meaning of the treaty. Obviously, then 3C, that means rules were not, well, it's easier with customary law because it's parties. You don't have, the question arises, who are the parties, in particular when you might have treaties where not all treaty parties are parties to the treaty, but that would exclude and rule out to, for instance, interpret one treaty with respect to another treaty, if not all treaties of all parties of the other treaty no, if all treaty parties are then parties to the other treaty. So applicable between the parties would be parties to the treaty from the whole perspective of interpretation, actually, and purpose. In terms of synallagma, obviously, the contractual treaties, no human rights treaties by their very object and purpose, and by requiring in the object and purpose, it's not the synallagma between the treaty parties, but there it's rather the generic, and there we might resolve it by reference to the text of the treaty, by referring, for instance, and then we are rather in the margin of appreciation. For instance, when using generic terms or broad terms, etc., we can reduce the burden of compliance by taking a more restrictive approach, but then more directed towards the application of the treaty, for instance, in that sense. So there it would be around the margin of appreciation, and the leeway a treaty organ has in interpreting and requiring more or less performance in that sense.
Katja? Okay.
Thank you.
Sorry.
So I think Thomas had a question about how generally do you frame a rule of customary international law? I think this is a really interesting question. I think, in a way, so I was talking about how modification of custom is really the test for identification being applied in a particular set of circumstances where there's pre-existing law. I think you could make a sort of similar argument for interpretation of custom, or what I think interpretation of custom would be, which is applying the test for identification, but when you're determining the content of the particular customary norm. And in this case, about the generality, when you're determining the generality of the rule, I think that turns on really the question of how broad or narrow a rule can a particular set of state practice support. So say you have a collection of state practice, how far can we deduce, and then how far down can we induce from that? So I think that's what I would consider interpretation of customary international law to be. I think what's interesting is because you're not constrained by a text, there is more flexibility than we would have in interpretation of treaty norms. Because you're not interpreting the particular set of words, you're interpreting the practice itself. So it's a different process that's going on. And I think quite a nice example of this sort of flexibility of the customary norm and how you can maybe interpret it in a different way than you would, with more flexibility than you could a treaty norm, is in the Gulf of Maine case, actually, when we see the ICJ reformulating this customary norm that they have identified to provide an answer to the particular case that they had to deal with. So I think that's an example of where you have more flexibility than you have with a treaty norm where you're constrained by a text. I think what they were doing there was interpreting customary international law, I would say the customary international law norm, because they were looking at the practice and reframing their particular characterization of that norm in a way that applied to the particular case at hand. There's also a question about subsequent practice and double counting. I think this is really difficult, not so much when you're looking at customary state practice that might affect change to a treaty, but going the other way. So say you have subsequent practice under a treaty that has caused an evolution in that treaty norm. Under what circumstances can that then affect customary international law? And that is much more problematic, I think, because then you run into the difficulty of finding opinio juris, because practice under a treaty it will be difficult, very difficult to establish. That they should also be counted as state practice for custom. I don't think it's impossible. I think it just requires positive evidence of opinio juris, and this I think is how you can get around this problem in the context of very widely ratified multilateral treaties like the UN Charter. In fact, we have to, because we know that custom has evolved alongside the Charter, and you do get examples of states, actually, like in the definition of aggression in the Friendly Relations Declaration, making statements about the treaty norm that are also clearly providing their opinio juris for the identical customary norms, which allows the two norms to evolve together through their separate processes, requirements being fulfilled. Finally, if I could just say a word about changing to Just Kogan's norms. I think that it is more difficult, I think, to create an exception to a customary norm, but I'm not sure it's impossible, because Just Kogan's norms, they prohibit invalidated, But the practice that might establish a customary norm that would derogate, practice isn't invalidated, it can't be invalidated. So these particular expressions of opinio or state practice for the customary norm that would derogate from the jus cogens norm, they will continue. I think the difficulty with restriction of a jus cogens norm is you really need the test for jus cogens to be fulfilled at the same time as the new custom is identified. Otherwise, it will be invalidated. Whereas with expansion of a jus cogens norm, you can have it in 2 stages. So taking the example I gave, you could have you have the jus cogens prohibition on direct force. You could identify a customary prohibition on indirect force, which then at a later time can then be recognized as also being jus cogens. When you're creating a new customary exception, you can't do that. It's either all or nothing. Either you create a customary exception that immediately achieves jus cogens status and modifies the jus cogens norm, or the customary norm won't arise.
Thank you, Katie. I'm looking at André Hoog. Would you mind?
Thank you. First for Dr. Johnston. You've phrased the issue in 2 scenarios of expansion and restriction, I think, of a prohibition. But you're kind of using the word exception in a specific meaning, namely limiting the scope or the scope of applicability of the prohibition. And there is some support for this. I know Judge Tomka has said something like that, and even the ILC has used the idea that if you invoke self-defense, then actually your use of force doesn't fall under the scope of the prohibition. I put it to you, first of all, that is wrong, because the right of self-defense is not an exception in that strict sense to the prohibition. It is a justification for the use of force, otherwise inconsistent with the prohibition. So what you have is a set of state practice, basically, which falls under 2 rules instead of just, the 1 rule. Now, the ICJ also in the Nicaragua case talked about exceptions or justifications contained within the rule itself, which might be seen as a kind of limitation of scope argument. But if you actually look throughout the judgment, it constantly talks about conduct otherwise inconsistent with the rule. And that's a justification argument, not an exception in the strict sense, limiting the scope of application of the rule argument. So my point, of course, because you're looking at the question of the requirements of customary international law to the creation of a new exception, is does that have an impact, for instance, on the extent to which the practice must be widespread, for instance? Because if you say that the practice for the new exception, the justification, is inconsistent with the existing prohibition, it falls under the scope of the prohibition, you can't quite expect the same kind of widespread practice as you have actually in support of the prohibition. So that kind of goes to your main premise, the requirements are the same. And I'm not too sure, especially in terms of practice, whether that's the case. So that's the first one. Then for Professor Binder.
Christina, that's fine.
The crucial point, about, of course, in the law of treaties and interpretation is when does interpretation, kind of transcend into changing of the meaning of the words. And that is especially, of course, there was a provision suggesting that a treaty rule could be changed by practice, but that particular rule was rejected at the Vienna conference. So, of course, the whole question between, the dividing line between interpretation and modification of the rule is very tricky, and I don't think we have very clear answers there. But it does go to the point, of course, what the limitations are of change. And personally, I'm very conservative. I don't like the idea of changing the meaning of words. We have a very clear example where that was done, which is, of course, the Namibia advisory opinion, where the ICJ said that concurring votes would not include would include abstentions, and only the veto, an actual negative vote, would constitute veto. The problem with that being, of course, that first of all, the ICJ never actually interpreted the word concurring votes and affirmative votes that you see in Article 27.3 of the Charter. It didn't really use the methods of interpretation, elements of interpretation to begin with. Never said what does the word to concur mean, for instance. And it actually used practice and general acceptance as the reason why we had to accept that. The problem is that that is, of course, an interpretation contra legem, because that really could not be based on a proper interpretation of Article 27. Different problems with that. Yeah. So that's the point. A final point on systemic integration, which of course has been made famous as a principle by our colleague McLachlan. Frankly, I don't see Article 31.3c as an integration provision. It was never intended as such. The idea is not to integrate the treaty that we interpret into the larger system. No, the point is we use the larger system to kind of shed light on the interpretation of the treaty, which is, not the same as integrating everything and kind of making treaties concordant with one another. Conflict is inherent in the system of international law simply because we're dealing with sovereign states who have different intentions for one treaty and for another treaty. Okay.
Thank you so much. Panos, you also want to raise your hand, please.
So a couple of questions / comments. Of course, I have to voice my minority opinion on the 31.3c issue on systemic integration, because I believe that, and there I'd like all of your opinion on the matter. In my view, the critical issue is not how you understand parties, but rather the term relevant. That parties should be understood in a way that you kind of weed out a few treaties in the beginning, and then you focus on determining whether it is relevant based on the language, how many parties are common, that kind of thing. The reason I'm saying this is that even the argument that parties to the treaty is the correct way to understand 31.3c, because it gives the treaty one voice, in my view, is not entirely accurate, because it is based on the presumption that the parties remain the same all the time. But in treaties, every single year, there's a new party coming in, maybe they leave, in which case the relevant treaties will constantly change, and the term and the understanding of the treaty will change if we go for focusing on parties. Whereas if you go for focusing on relevance, then the meaning can become much more stable, because you take other things into consideration, whether truly that treaty that you're referring to is indeed relevant. But there, I'd like to hear your views on the matter. The second point is with respect to Article 20 on jus cogens. And I would like to ask Dira if, because in the earlier drafts we had seen, this is interesting for us because in earlier drafts, I think the presumption was only for interpretation of treaties. And at the end, that draft changed in order to simply refer to any kind of rule. And I would like to ask whether this was intentional or was it more simply, just for drafting purposes, it just made more sense, whether it was a discussion on this particular point. And the final point, and I'm wrapping up very quickly, is to Katie as well, because you mentioned the Gulf of Maine case there, and you said this is more interpretation of practice. I can see that point. I still think that it was interpretation of the rule. But then the question would be, what about all the other situations where the reference is made to the object and purpose of the rule? So not taking into account practice, not taking opinion serious, simply the object and purpose of the rule. And an example I could refer to is nowadays the discussion about the application of IHL principles to situations in the cyber, basically. And Germany, for instance, made a released a white paper where it specifically said that if we look at the object and purpose of the principles, then clearly these apply to such a situation. So would you say that this falls in the classical format of state practice opinion jurors, or is there something else? And I'm done. Thank you.
Thanks a lot. We have another 15 minutes before the break, and realizing that it's hard enough to participate online, I would like to first give the floor to Dire for his response. Thank you.
We can't hear you.
Voilà. I think you can hear me now. I'm sorry. So I'll start with the questions that were directed to me in particular, and these were questions from Pano. So the first question or the first comment on Article 31.3c, I guess my response to you is be not clear why they can't be both relevant. Why both parties and relevance can't be significant. And yes, you're right. Parties to the treaty change, and so that might, to some extent, suggest. That might suggest to some extent an evolution of the treaty. But again, it doesn't. I don't see how that discounts that the meaning of the word parties in Article 31.3c refers to parties to the treaty. I think you're right that so that relevance is also of significance. But I don't see that as being mutually exclusive with the understanding of the word parties in the way that I've described. As far as draft conclusion 20 is concerned, I actually can't even remember what I proposed, but I do know that in the first reading text already, referred to all the obligations, right? And so it may well be that it was in the course of the drafting committee that the change was made. I was actually trying to look through and see in my own report what I proposed. I really can't remember. So that would have been in the third report in 2019, I think. So I'm really not sure. I think that's the answer to that question. I can't remember the exact evolution. The only thing I can say for sure is that from the first reading to the second reading, there wasn't any change of draft conclusion 20, so that it remained applicable to all obligations that are covered in the draft conclusions. And then a couple of comments on questions that weren't directed to me. And here I'll just make a brief comment. So on the exception, scope, and self-defense, my approach has always been, and I'm not sure whether this means that it's an exception or delimits the scope. It's always been that self-defense, in fact, is an inherent part of that rule. And so often when I speak about the rule, I unless I'm using shorthand, I don't use the rule on the prohibition of use of force. I talk about the rule of the Charter relating to the use of force, which I think includes the rule, and also the exception to the rule. That's just my approach. And then as far as the Namibia opinion, I mean, I'm also conservative in that respect, and in fact, in respect of the work on subsequent agreements and subsequent practice, I was very concerned about the approach that I saw the Commission taking, in which the Commission seemed to suggest very strongly, it seems to be implicit in the work of the Commission, that in fact subsequent practice can, in effect, in practice, modify treaties, even if it's not a formal modification. There was, in fact, I immediately after we adopted that, I penned an EGIL talk blog post in which I addressed that particular issue. That said, though I agree with your basic sentiment, I do want to defend the ICJ a little bit. That not only because I think the decision was, from a policy perspective, correct, but even in terms of at least in terms of its methodology, right? And so, leaving aside whether or not it's legally correct or not, in terms of its methodology, I don't think there was anything different in the Namibia approaches, in the Namibia opinion's approaches to sort of describing how the court comes to a particular conclusion on interpretation. The court tends to be, or is very often brief, and very often doesn't describe fully its steps, and that's a flaw. I think it's a flaw generally in the methodology of the court, but I don't think one can point to that to say, well, in this particular instance, because it's just simply what the court does very often. So I'll just leave it at that.
Okay. So exceptions and limitations, yes, I have been using the word exception very loosely in my presentation. I wasn't clear if it was a limitation on scope or a separate rule that provides a justification for conduct that is otherwise prohibited by another rule, and that was deliberate or it was conscious. The lack of specificity with which I used that. So I think in the jus ad bellum or in the law and the use of force generally, part of the complexity of that area of law is that actually we see these different types of exceptions as limitations on scope and separate rules. And I think that arises because of the coexistence of different sources in the law and the use of force. So I think you can see, for example, we have Article 51, so the treaty-based version of self-defense. I think we can say that that is a true exception, so is a separate rule that provides a justification for a violation of existing rule. I think, but on the other hand, then we also see limitations on scope. So I think collective security, I think because it arose at the same time as a sort of crystallization of the prohibition on force, as Professor Tladi says, I think that's part of the rule itself. My problem with self-defense as a customary rule, as an exception or limitation to the customary prohibition, is I find it very difficult to see how customary international law, as I understand it, can permit and prohibit contradictory things if you apply this test for identification. So perhaps we just take different views on this. But for me, it's difficult to see how customary international law can simultaneously prohibit and permit separate things. I think for me, the better answer would be to interpret customary international law seamlessly or holistically, so that it only gives one answer, and that is that force in self-defense is lawful under customary international law, which I think is what Deirdre was saying, that it's part and parcel of the rule itself. It's just not prohibited. I think you can then draw a distinction with Article 51 as the treaty norm, which as a separate source of law, you could have, as a lex specialis actually, provides an independent norm that acts as a justification for violation of a customary prohibition. But I think it's complicated. And I think it depends on the interaction of sources as well as just the interpretation of state practice and opinio juris. Part of the problem, though, I think, in trying to determine if things are limitations on scope or true exceptions is, especially when custom is, I think states just don't address these conceptual issues in either their practice or their statement. So it's very difficult. You know, if a state says an act in self-defense is lawful or unlawful, usually what they mean is it's lawful, all things considered. They rarely in practice tell us that this is because they think it was wrongful but justified. So first of all, I think there's an evidential problem in customary international law. I don't really know how we would answer that question as a matter of practice to determine if self-defense is a limitation on the customary prohibition or justification to the customary prohibition that they somehow overlap. So there's an evidential problem conceptually. I find it difficult to see how customary international law, if we accept it as arising from a widespread and representative practice accompanied by opinio juris, could ever permit two contradictory things. I find that difficult to understand. And then briefly, the object and purpose. Yeah, so I mean, I think part of the problem is the same thing. I think states sometimes are a bit loose with their language. They're talking about the object and purpose of a customary rule. Perhaps that's a reference to the Vienna Convention rules, or perhaps they're using familiar language, I think, to engage in what I was talking about earlier, which is how do we interpret state practice to induce from it a rule, and what are the limits of what is legitimate to extract from a state practice to extrapolate out a customary rule. So I think object and purpose is a fine way to speak about it, but customary international, really, it's objectless and purposeless, isn't it? It's practice that arises from the concordant practice of states. There's no meeting of minds of states. So I think they're probably using that language because it's familiar, but I would be skeptical that that means they're applying the Vienna Convention rules to a customary rule. I mean, the VCLT rules, you know, they're rooted in the text of the treaty, so I find it a bit difficult to then just map that onto interpreting a customary rule. I think interpretation of custom does go on in the sense that the content of the norm must be determined. But for me, that's an application of the test for identification with the challenge that it presents in that particular context rather than the mapping of the VCLT rules.
Well, in terms of, first of all, interpretation, your question, I would also be rather conservative in terms of the meaning of the treaty. However, there are some examples where actually it's obviously, for instance, the UN Charter and Soviet Union replaced by Russia, the seat. So we can have to a certain extent, and I think that can be argued via the principle of good faith. In the interpretation of the treaty, so when there is no, but the borderline would be obviously when the burden of one party increases. And actually, you referred to the Namibia opinion, and just to cite the dissenting opinion of Judge Fitzmaurice, where actually when it came to the automatic, from the shift of the trusteeship system league to the Assembly of the United Nations, where he stated it would not be a valid judicial reading, the automatic conversion of an obligation of accountability to the League Council into an obligation towards the Assembly of the United Nations. And there exactly, but even though with the trusteeship system, you might even argue that in terms of human rights treaties, most broadly speaking, you might be more generous in terms of, and there we are once again, what increases a burden of a party, and human rights treaty might be different from synagmatic treaties, where it's more the contractual relationship. But there, I think there is a certain argument to be, well, conservative as basis, but then certain more generous understanding from the perspective of good faith in relation to treaties which are not purely contractual, where the burden is not increased. But yeah, your question in terms of Article 31(3)(c), what is the moment which matters in terms of treaty parties that change? Well, it's to a certain extent the principle of contemporaneity. What matters at the moment of conclusion of the treaty or the moment of application of the treaty. And there, once again, I would refer back to state consent and the use of, and actually it's the terms which say the use of generic terms, whatever human, and so to a certain extent, I think the problem of which parties, the relevance or the parties, we can avoid it by referring to these, to the very back to state consent, which moment matters for the interpretation of the treaty. And then these treaty parties, the rule applicable between these treaty parties, counts actually, and these treaty parties would count.
Thank you very much to all the speakers for their excellent presentations and for the very sophisticated discussion. As an international health lawyer, I'm very impressed by the level of this conversation, and also I feel that this is very important that people like you are doing this research and contributing to international law as a whole. I would like to clap for all the speakers. Thank you all, and to the audience. And it's always very difficult to participate, so let's all wave at Diri to thank him specifically for his ongoing attention to this event, and thank you for being here, and we really regret not to be able to meet you in person. And I look forward to continuing the conversation during lunch. Bye-bye.